A leaked Justice Department white paper says the Obama administration has the right to kill U.S. citizens affiliated with al-Qaeda. I'm Catherine Rampell for the New York Times. Scott Shane has been covering the story, and he joins me now from Washington. Hi, Scott.
Hi, Catherine.
So tell me a little bit about this memo, or white paper, I guess. Under what conditions does it say that the administration has the right to kill U.S. citizens?
Well, as you know, the administration has withheld from the public much longer classified memoranda, legal memoranda, laying out what it believes is the government's right to kill even Americans who they believe are terrorists plotting to attack the United States or to attack Americans. This white paper is unclassified. Those longer legal opinions are classified. The white paper is 16-page summary, it appears to be, of those longer classified memos. And it was obtained by NBC News and put up on the web last night. It's the first sort of internal document that gives us a little more detailed glimpse of the Justice Department's logic in saying when an American can be killed. Essentially, it says that if government officials have reason to believe even an American citizen is posing an imminent threat of attack, they have the right to kill that person without going to court, without taking any other actions.
And what is an imminent threat? What does that mean? Does that mean that there's somebody has their finger on the button right now and is about to blow something up? What does that mean?
Well, that's one of the interesting things, and I think probably likely to be hotly debated in this memo, in this white paper rather. It says that it does not have to be somebody who's about to push the button and blow up a bomb. It has to be someone who's part of a group like al-Qaeda that's consistently plotting and intends to attack the United States, and that's enough to meet the standard of imminent attack.
The administration has been pretty secretive about these types of conditions. Why is that?
Well, that's a great question. President Obama came into office pledging to run the most transparent administration in history, and he actually incurred the wrath of some former CIA directors by releasing the Bush administration's legal opinions, secret legal opinions on interrogation and torture. But in the case of his own, secret legal opinions on targeted killing, the drone campaign and so on, he has, in fact, taken the opposite tack. They've kept them secret. The New York Times and the ACLU both filed lawsuits to try and obtain these secret memos, and at the first level, we've lost those lawsuits, and the administration has been allowed to keep them secret. Those cases are on appeal now, but they have gone to great lengths, it's fair to say, to keep their own legal opinions secret. Even this unclassified white paper, which has no intelligence information in it.
It's just about policy.
It's about policy. It's about legal reasoning. And I had heard about it and filed a Freedom of Information request for this document last month after the Justice Department refused to give it to me. And ironically, just a few days before it was leaked to NBC News, the Justice Department wrote me back and said that it was withholding this document on the grounds that it's a draft. Now, I'm suspicious that is a bit of a fraud, in the sense that this draft has apparently never been turned into a final document, and it has been distributed to a number of members of Congress. So I can't help but suspect that the reason it was labeled a draft was, in fact, to withhold it under the Freedom of Information Act, because there's an exemption for for sort of internal deliberations that allows you to withhold a draft document.
Well, Well, and it's not just that they're withholding information, about this final legal reasoning from the public and from the press. Part of the reasoning within the document, as I understand it, is that there is no oversight of the process itself. There's no judicial oversight. That courts are not going to be able to determine whether or not there is an imminent threat, which means that the executive branch can order effectively an assassination of an American citizen. Why is that?
Well, that is one of the certainly most debated points of this whole legal argument. As people will recall, Anwar al-Awlaki, who was a radical cleric born in the U.S. and therefore a U.S. citizen, was killed by a drone strike in September of 2011 in Yemen. He's the only person we know of who was targeted by the government to be killed, although another American was killed with him, and Anwar al-Awlaki's son was killed a few weeks later in what appears to have been a mistaken strike. But when people are asked, do you think it's justified to use a drone to kill Anwar al-Awlaki, many Americans would say yes, because he was known to be plotting against the United States. He'd helped send the underwear bomber in 2009. But if you ask, should a president have the power, without any court's review, to designate an American as a dangerous threat and have him killed, a lot of people have qualms about that.
Yeah,
so I have a feeling this debate's going to go on for a while. What
has the reaction been? I mean, has the ACLU weighed in or others?
The ACLU last night issued a statement calling this white paper chilling. They've opposed targeted killing of this kind, and so that reaction may not be surprising. There's quite a bit of criticism out on the web today from early legal analysis from various legal authorities. It'll be interesting to see as the day goes on how Congress responds and how perhaps mainstream law professors, when they get a look at this, judge the quality of the legal reasoning.
Well, thanks very much for coming on the show. We'll be watching this.
Thanks for having me.
That's all for now. I'm Catherine Rampell for the New York Times.